Thank you very much, and good morning, everybody. It's a real delight to be here, to be chairing this panel for the third year running, and it's a real delight to be here in Amsterdam as a London-based expert. It's a good reminder that not all of the class action is going on in the UK. As we heard from the previous speaker, there's a lot of it going on here. And if we needed any more of a reminder, the recent case announced against Google, a whopping 22 billion pounds or perhaps euros claim, the vast majority of that claim that's been filed in London and in Holland relates to claims on the continent. We are going to be, as a panel, reflecting on the emerging sort of case law, in particular coming out of the UK, for the work of the quantum experts. And to help me do that, I've got, again, a great panel. Unfortunately, not all of us could be here in person. COVID had the last laugh on Greg, but Greg joins us again for the third year running. Greg is a veteran antitrust damages expert. And to give you a flavour of what's going on in the UK, Greg revealed that he's probably going to be just doing class action work until he retires. I know how he feels. Also joining us is Jouni Sohkanen from Copenhagen Economics, heads their European disputes practice, a seasoned competition economist with experience working on cases in the UK and on the continent. And some of you may have caught my small news in the last 12 months, so I'm now delighted to be able to call the final panelist, Vikram Kumar, a colleague. Vikram is a principal and a PhD economist at Cornerstone Research. Again, very experienced on antitrust and antitrust damages cases, and currently working on 4 class actions in the UK, 4 and counting. We're going to give you a whistle-stop tour of some of the key elements of the quantum work and how the emerging case law is impacting what we as experts have to do, certainly at certification, and we'll be trying to sort of read the rooms of any implications for that work at trial. Let me just give you a quick catch-up of what's been going on in the last 12 months in the UK. We have a full boom in flight. We've had an extra 7 cases filed. We've had 6 certified. We now, even before the Google one gets filed, we have now over £42 billion worth of claims going through the UK Competition Appeal Tribunal. And the judgments are there for us all to read. There's hundreds of pages of judgments. There's thousands of pages of transcripts to sift through. Often involving a lot of interrogation, actually, of the economic experts and their proposed methodology. And all that reflects a low bar for certification in the UK, and it's a low bar for what the experts need to bring at the certification stage. So no need for common impact, no need for predominance of common issues, but also for the experts, no need to rely on best practice. No need, apparently, to specify your counterfactual at certification. Certainly no need to specify your survey. The broad axe is being wielded, and the watchwords are flexibility and pragmatism. And then a final reflection on the nature of some of these cases, and I was interested listening to the previous speaker about some of the anxieties of avoiding the excesses of the US system. I was reflecting on this recently at Fordham. I think in the development of the regime here, compared to the US, a lot of solace was taken by the fact that there weren't treble damages. I'd forgotten there was a proposal initially for double damages, that we have judges, not juries, that we have adverse cost rules. But perhaps the biggest thing that was missed, the biggest difference between the US and Europe, is that over here we have exploitative abuse. And boy, is that being stress-tested in the UK cases at the moment. So traditional excess pricing cases, App Store, Play Store, Qualcomm, BT, even Meta, but also non-price abuses. So is there a special responsibility to replace defective batteries more quickly, to advertise lower fares more aggressively, or give more optionality over use of data. Some are arguing that that is simply a shoehorning of consumer law cases into antitrust cases to get the benefit from the opt-out regime in the UK. By the sounds of it, no such sort of forum shopping need to be applied over here. Perhaps Holland will provide a natural experiment, something that us economists really like. We did trail some of this last year, actually, and we worried whether we were being a bit Cassandra-like, but of course Cassandra was right, and we are seeing, I think, a perfect storm of a low bar and increasingly novel cases, and I think this may well play out with some very different dynamics post-certification to what we see in the US. So that's all I wanted to cover by way of opening remarks. We're now going to kick off with Greg, who's going to set the scene for us in terms of the quantum methodology. So, Greg, there you are. You've got a new case that's just landed on your desk. I know a bit more goes into it than that. But it's pre-disclosure, so you're in the dark on a lot of things in terms of data. Just walk us through how the expert goes about putting together their approach for a plausible methodology that's going to meet the standards of proof and is going to be digestible to the court for addressing the quantum issues. We don't have any volume by the sound of the looks of things.
Okay.
Great.
Is that better?
We've got you.
Okay, good. Yeah, so look, good question. Let me, kind of concentrate on the damages framework, obviously, as opposed to all the other things that would have to go into a standalone claim, such as market definition, dominance, and theories of harm. So, assuming that we have a starting position upon which to think about damages, how does one proceed? Well, the starting point, of course, is what is the framework? What is the nature of the damages? Now, the standard measure of damages under English law, at least, reflects the compensatory principle. So that is, the damages should put the claimant back into the financial position they would have been absent the alleged wrongful act. Now, this standard is frequently used in cross damages claims. It's widely used in the High Court in the UK, other jurisdictions outside of the UK, and in commercial and treaty arbitration. And with respect to damages for breaches of competition law, we see from the interchange cases in the UK that the Supreme Court has stated quite clearly that the fundamental principle of damages was compensatory, and noting in the interchange cases that merchants were entitled to be placed in the position that they would have been but for the tortious act that caused them the loss. So that's the starting point, putting the claimant, the class, back into the position that it should have been in. There's then a question as to whether one can consider aggregate damages across all of the class, or do you need to think about damages at the class member level? Now, thankfully, we now know that class members may seek an award of aggregate damages. That was always set out under Section 47C of the Competition Act 98 in the UK, and the Supreme Court has also confirmed that position. So it's not necessary to determine the level of damages for each class member, which obviously makes damages easier, especially at the CPO stage. Now, whether sufficient data subsequently becomes available for one to be able to drill down will depend on the nature of the information that is available. I imagine that a lot of these cases that we're seeing in the tech world may be data rich enough for disaggregated claims to be considered. So, having a standard, knowing at what level of damages we're going to calculate, the next question is, well, how do you go about that? Now, normally, we would consider the difference between two scenarios. The financial position that the class would have been in, absent the wrongful acts, which is often referred to as the counterfactual scenario, and the financial position the class was actually in with the wrongful act, the actual scenario. So, for example, if the harm was exploitative in nature, say, with respect to, let's say, excessive pricing, then, so an exploitative case, then the actual scenario will reflect the prices consumers actually paid, and the counterfactual would reflect the prices consumers would have paid absent the abusive conduct. If it was exclusionary in nature, such as a foreclosure, then similarly, the actual scenario would reflect profits actually earned, and the counterfactual scenario would reflect the profits that would have been received absent the conduct. Now, in this kind of foreclosure world, there can be a little bit more difficulty because there may be a forward component to the calculation. If they'd been foreclosed from the market forever, then obviously there's potentially a claim for future losses that are yet to be incurred. Or the abuse, after the abuse, the market share of the claimants may not instantly bounce back due to lingering effects. And I've seen that in many cases, especially if consumer decisions are influenced by things such as loyalty programs that post the infringement, there are mechanisms that make changing consumption more sticky. Now, normally the actual scenario is the easier of the two, but of course in foreclosure claims there's also the complication that you might have to forecast what would have happened in the actual scenario with the abuse and the counterfactual forward without the abuse. Again, that makes it slightly more difficult than potentially a more straightforward excessive pricing type of claim. Now, just thinking about the counterfactual, that is often difficult, especially at the CPO stage, due to information asymmetries that arise prior to disclosure. But what we're trying to do with the counterfactual, given a theory of harm, is to determine what the dominant firm would have done differently absent the abuse. And that can be difficult. Now, again, thankfully, the UK case law has established, at least at the CPO stage, it's not necessary to be precise about the counterfactual. So in Gutman Boundary Fares, it explained, for example, that an unfair price, in respect of an unfair pricing case, the excessive price can be shown to constitute an abuse without specifically or precisely saying what that non-excessive price would be. Now, of course, not being precise, I don't think that gives license to the claimants to be vague. It still needs to be a credible, reasonable counterfactual, but you don't have to necessarily alight at the CPO stage on exactly what that counterfactual would be. So then just, trying to think a little bit about how you would step through these types of case. So let's take, an example. So let's say that it was, pardon me. Let's take an example of an unfair price charged to developers of apps and games in an online marketplace. I'm not going to refer to an actual case here, but I understand that there may be several cases of this nature flying around the globe at the moment. So step one, determine the financial position in the actual scenario. So in this actual scenario, it might be alleged that the dominant undertaking raised the price to third parties who use the digital platform or marketplace to sell digital applications, games, add-on content, and so on. And without getting into any specifics, it's likely that the rates the dominant undertaking charged and the level of revenues that those rates generated can be determined at the CPO stage to some reasonable degree. Of course, I'm generalizing here. And actually, determining the price actual position, may be a little bit more difficult and will certainly need to be refined once disclosure is obtained. Then one needs to consider what the counterfactual would be. I mean, in this example, it would be that absent the excessive price, app and game developers would be charged lower prices. Though there would be then some question as to what it did with those prices and whether there was pass on. Now, I don't have much time to explain how one might determine that the prices were excessive in the first place. such as by reference to the United Brands framework. But for these purposes, one can just go to the second limb and consider whether prices were unfair by reference to comparators in the marketplace. So comparing rates across digital marketplaces over time would provide an indication, a prima facie indication as to whether those prices appeared high. Obviously, once you have disclosure, then there are other mechanisms that could be applied to assess the degree of price excessiveness. I should note at this stage that when you're looking at two counterfactuals that have different prices, obviously there could be a volume effect as well.
Yeah.
So,
sorry, Greg. Thanks. Did you want to just finish that off?
No. I mean, it depends on how much time I have. I could go on, but if
I think you've laid out the sort of main planks of that. I just wanted to bring in Jouni on perhaps stepping away from the sort of excess pricing type cases to some of the other digital cases and non-digital where we've got a counterfactual that may involve a materially different supply situation, so not just a sort of lower price, but some of these self-preferencing cases, and we've seen this on trains, where part of the challenge is going to be sort of figuring out how consumers might have reacted to that very different, potentially very different counterfactual. How do you want to just pick that up, Jouni, and how good are the sort of techniques that we've got at our disposal to address that question?
Yes. So the essence of the allocation in trains, which has now been certified, CPO and an appeal court has also given a judgment on that, confirming it. I'm looking at it as an observer from the outside, I have to say. The idea is that because of the way choices were presented to consumers, they made a choice that in some sense was less good than the choice they would have made had the choice been presented differently. Now, for the purposes of the CPO application, the court didn't find it necessary for the applicant's expert to specify exactly how the choice should have been presented. It said something like they would have been widely available in the counterfactual. That was enough. Why would it matter for the economic expert to eventually decide on how the choice would have been presented in order to quantify the damage? Well, here you already alluded to this difference, but in a sort of run-of-the-mill cartel case or in a traditional excessive pricing case, we have a situation where the counterfactual involves lower prices of the products that were bought in the actual scenario. And the demand side is therefore simple. The consumer pays less for the product and possibly buys more of it. That's the only consequence, really. Here, there's some kind of switching. You choose a different fare. You choose a fare that avoids double paying for a portion of the journey for which you hold a travel card. Now, the court didn't think that this meant that everyone who did this double paying actually suffered damage. So they said, okay, it's not a strict liability approach. There may be zero loss claimants. And in fact, it went further and said in every class actions there will be zero loss claimants. But you can protect the respondent's interests by reducing the aggregate award accordingly. So the economist has to quantify the damage. One of the aspects is how much do you reduce that award, and that has to do with how consumers choose in the counterfactual. The first thing to say is that it's hard to avoid specifying quite precisely what the counterfactual looks like in this kind of case. I'm not going into what will be required by the court. I have no idea what the standard burden of proof will be from a legal perspective, but as an economist, one has to state what the choice looks like. And in order to find that counterfactual, one has to think about what is it that the company has an obligation to do. Think about two scenarios. So I go to a ticket counter or a ticket machine, and the first thing I'm asked is, do you have a travel card? I present a travel card, and then I'm presented with a tailored option, maybe even not presented with the option where I could overpay. That's a different situation from being presented the full menu of options with some text behind some menus that I could go and read with some effort. So it matters how the company's obligation is perceived? Is it to eliminate behavioral biases of the consumers, or is it merely to give the information and make it available? But once we've formulated the counterfactual scenario, there are well-established techniques to analyze choice. And just a very brief overview, typically when economists analyze consumer choices, we think of consumers valuing attributes of goods. We have models that assign values to the attributes the goods have, and then we can change the attributes and the consumer's valuation for the goods changes, and because we assume consumers choose the goods they value the most, the choice changes accordingly. Now, in these cases, like trains, it's of course arguable whether it's really an attribute of the service or whether it's the framing, but the framework could be extended, generalized to account for that. And there are two ways to approach that analysis. One is to find a benchmark case, maybe after the infringement comes to an end, see how choices change, use what's called revealed preference data, looking at how actual choices of consumers change, or it would be to design hypothetical scenarios to put to the consumers in a survey and use the preferences they state for different services and analyze those. Now, obviously, a challenge that's immediate, obvious, I think, to people from that kind of stated preference data is can you really put someone in a position where they rush to the train station and they need to make a decision by simply asking them to look at a piece of paper or an online survey. There are sort of experimental economics, behavioral economics techniques to try and get around that, to sort of mimic the real preferences more closely. But it'll be interesting to see whether such debates arise at trial. I don't know.
Absolutely, absolutely. Thanks for that. Jouni, I'm going to stick with you in a moment to talk about, we're going to do a deep dive on overcharge techniques, but just one final comment on Greg's overview. You talked about future losses, and it reminded me that one of the cases we're seeing before the CAT has losses going out to the year 2060 due to the mechanisms of how certain costs filter through electricity price controls. So I think at some point, having resolved the question of whether the claimants can claim on behalf of deceased people, presumably the Supreme Court is going to have to address the question of whether claimants can claim on behalf of people yet to be born in the UK. So we'll see how that pans out. So Jouni, yes. So overcharge. Obviously overcharge can now feature in a number of different ways. There's the traditional cartel overcharge. We've also got excess pricing cases, which essentially involve an overcharge, or indeed higher prices flowing from exclusionary cases, and potentially some of these self-preferencing cases. Jouni, just sort of unpack the toolbox a little bit for us. Of how the experts will be going about addressing the overcharge challenge, and what are we seeing in terms of some of the sort of messages coming out of the court that's relevant to this?
The toolbox that's typically applied, or let's say the choice of tools available to economists in these European cases, UK cases, is described in the 2013 Practical Guide published by the European Commission, and it walks through at high level the tools that are available and then goes into a bit of detail about implementation. The spoiler alert is that you will need an economist to actually apply the techniques. It's not a guide that you can follow step by step. There's a lot of background to it. Broadly speaking, it covers three types of methods, so the toolbox has kind of three compartments. The first compartment, which is very often used and reached into, is the compartment of comparator-based methods, where you observe the actual situation, you have data from the affected market, and then you find a market that is comparable or can, with clever application of statistical tools, be made comparable to the actual market, but for the impact of the infringement. And those comparators come from the same market from a different time period before or after the infringement. They come from a different product market during the same period, or from a different geographic market, or it's a combination of time periods and geographic or product markets. And the choice of techniques within that toolbox is largely driven by the availability of data. Then the second compartment is a sort of mix of several methods that are kind of, I would say, often viewed as secondary, sometimes applied. Simulation models, which are kind of full economic models that specify how the market works in theory, and then there's a switch that you flick and you turn the infringement off and you see what it is that does. So it's not really a testable hypothesis whether there's an effect, but the magnitude of the effect is somehow calibrated to what the market looks like and what the assumptions are about the counterfactual. And then there's sort of cost-based methods which start with some measure of cost for the good, could be benchmarked from a rival or could be the company's own cost, and then you add some kind of reasonable markup, and here you have to again benchmark. So you can't avoid benchmarking. Finance-based methods where you look at the impact of the infringement on the perpetrator's balance sheet, and again you might want to or need to benchmark either the post-infringement period, or you might use some theoretical benchmark like cost of capital as a kind of floor for profitability. And then the third compartment is other methods. This is not a closed suite of tools, and it is left open. You use a method that allows you to get to the counterfactual. Basically, that's the message.
Okay, great. Vikram, let's bring you in here. One question that we experts often get asked is, we've got all these tools for calculating quantum. How good are they for demonstrating or even proving causation?
So I think if you're thinking about regressions, for example, they are fundamentally a tool for analyzing correlation. That said, a carefully put together regression model which accounts for all factors other than the one in question appropriately, or ones that rely on natural experiments, can get us pretty close to what the actual causal impact is. So while it is fundamentally a question of fundamentally a tool for analyzing correlations, you can get pretty close to the causal impact if done properly, and that's the key.
Yeah, I think my answer to this question is we shouldn't let perfection be the enemy of victory here. I think it was David Hume that said that all knowledge descends into probability. When you're using regression models, you're often using the traditional sort of statistical notions of statistical significance, which tolerates the possibility that actually you may be wrong and you may be producing a false positive, but you try and keep that to a small percentage of sort of 5% tolerance, and all economic analysis. Indeed, actually, the court's assessments here are really all about sort of balancing the risk of type 1 error and type 2 error. I suffer from type 3 error, which is never quite remembering which way round those two go. Actually, just on that question, Greg, there was a Nobel Prize-winning economist who once said, look, if you torture the data long enough, you can get it to confess to pretty much anything. How does the economist sort of make sure that what they're doing is objective and can be demonstrated to be objective? And in the words of a famous paper on this subject, how do we make sure that we as experts are taking the con out of econometrics?
Yeah, it's a good question. I mean, I think that if you look at the EU guidelines on some of these things, it puts forward a preponderance of evidence type of approach, using both quantitative and qualitative data and findings. And I think it's the qualitative data that can help to take the con out of economics, right? Because if you come up with a model that just doesn't fit with the underlying evidence trail, then you have to be a little bit suspicious. So I can give you an example of this in the Sainsbury's MasterCard cases. There was a claim for interest at the weighted average cost of capital, and the economists on that case, based on a theoretical proposition, said, if we assume that the company is efficient, and look, here in the statutory accounts it says we are aim to be an efficient company, that's an audited statement, so it must be true, then at the margin, then the marginal cost is at the weighted average cost of capital, because you're already at the lowest point. And if you take out a little bit more debt, that has an implication on the cost of equity, and these two things balance out, right? And it was a very persuasive argument. There was lots of theory, lots of references to clever people that had won Nobel prizes, and all the rest of it, right? But the simple fact was that when you actually looked at the financial record, what you saw was that debt was constant through the period. You saw that equity was constant through the period. The level of dividends paid through the period were constant. But what varied was the amount of cash, because it was a big business and it had huge cash amounts. And I can remember seeing the tribunal look at some of the graphs that I took them to under my cross-examination, and it was just clear that here was an instant where theory and practice were not, in tune, and it led to the judgment that it did, that it shouldn't be at the weighted average cost of capital.
That's a really nice example. It reminds me of, in fact, one of the last economists to win the Nobel Prize, Ben Bernanke, who once famously said about quantitative easing, it works in practice, but it doesn't work in theory. So that sort of making sure the theory and the evidence sync up is absolutely essential. Okay, we're going to shift gears, and we're now going to talk about the next phase of the analysis, which I think Greg trailed earlier, and that is pass-on. And there's a bit of history here. There's certainly a lot of history from some of the parallel proceedings in the UK around interchange. And where the court started out in all of this, one of the early cases, Greg, I think you were involved on this, was the court sort of said, yeah, we get the economic theory. We get the idea that if costs keep going up and you don't pass them on, you run the risk of becoming an ex-business. Students of Monty Python will note the nod to the dead parrot sketch there in that phrase, ex-business. I think that's gone over the heads of quite a few people in this audience. And so there was this focus from the courts on, well, but what's the direct evidence? How do firms set prices? What is the nexus between costs and prices in the business? We want to see that. We want to see that in all its glory. And actually, in a very recent judgment, the court has now said, actually, that's going to put a huge burden on claimants. And actually, we'll go back to restricting the defendants to only using econometric analysis. But if the claimants want to bring forward sort of direct evidence, then they can. So it's sort of gone a little full circle. Vikram, I'm going to bring you in here. There was one economist report that attempted to summarize the economics of pass-on and recommended that the court merely follow 39 steps to addressing pass-on. I'm hoping you're going to do a better job of synthesizing, Vikram. What are the sort of key elements of the drivers of pass-on from an economic perspective?
I will restrict it to 3 instead of 39. So, so the fundamental question is fairly simple, right? Which is that, okay, there's been an overcharge. To what extent is that overcharge going to flow through the different levels of the supply chain, right? So to what extent does the direct purchaser of the product that's been for which there's been an overcharge, to what extent do they pass on that higher cost to their customers downstream, and also to what how does that affect the volumes of their sales? So that's the volume effect that we spoke about earlier. Now, in terms of techniques, really it's basically the same techniques that Jouni mentioned earlier for assessing overcharge in the first place, but just applied to a different level of the supply chain. However, there are a few things that one needs to consider here. So, the fundamental question at the end of the day is, how are prices being set in the market, and in particular by the direct purchaser, right? So in that sense, it's actually important to think about, what the market looks like, what the market conditions are that the direct purchaser is facing. So if you look at the guidance, the guidance says that there are basically 4 key factors that one needs to think about. So the first one is the nature of the input costs. So economists, typically recognize that, fixed costs firms may not pass on in the short run. They may be passed on in the longer run, but in the short run they don't. Variable or marginal costs may be. Then there's a question of whether this, overcharge affects all direct purchasers who are affected by the conduct, or is it only an individual single direct purchaser who's affected by the conduct. Then there's the question of, what does the demand look like for the direct purchaser? And this, I touched upon this earlier, which is, really, who are they selling to? What does demand look like? How sensitive are the direct purchasers' customers to price changes? The third would be competition, right? What are the competitive conditions that the direct purchaser is facing in the downstream market? And then there are a bunch of other factors. Now, if you look at the guidance, each of these, on the face of it, it looks like each of these are distinct components. However, really as economists, as I mentioned earlier, what we need to be thinking about is, how are these firms actually setting prices? What is the price formation process? What does that look like at the direct purchaser level? And for that, you need to think about all of these components together, right? So in particular, right, if you're thinking about a situation where a single firm is affected by the overcharge, and it's operating in a really competitive environment, then its incentives to actually pass on that overcharge to its consumers may be lower. So that's one instance, for example, where each of these items feeds into how the extent to which the direct purchaser may want to pass on their higher costs. Another example, would be a situation where if all firms, all direct purchases are affected by the overcharge, and it's a highly competitive industry, then one would expect pass on to be much greater than otherwise. So these are factors that one really needs to consider. Just one thing I wanted to mention on techniques, which is obviously not relevant for Jouni, which is one way to do this, that which even the guidelines refer to is something called the pass-on rate method. So here the idea is that okay, fine, I understand that there's been an overcharge. To what extent has that overcharge been passed on to consumers downstream? So what you could do, drawing a parallel with what Jouni mentioned, was to say, okay, look, what does pass-on look like at a point when there was no infringement, right, either before or after? And I say, okay, let's say 50% of a firm's variable costs are passed on. I'm going to assume that same 50% is going to apply even during the period of infringement, and then apply that to assess pass-on for the period of infringement. Now, this involves 2 fundamental and pretty important assumptions. One is that, yes, there would be a pass-on during infringement, and 2, that the pass-on rate would be the same as it was outside the period of infringement. And those are pretty important assumptions. The third complication here is that often direct purchasers buy many different components, many different products, and then put all of those together and then sell widgets downstream. So now the question is, how important is this one product that was subject to the overcharge? If it was a really small part of the direct purchaser's production, then it's an open question whether those, any overcharge for that one component would even be passed on. So these are things that one really needs to think about carefully.
So just on that, we're seeing a number of these cases, aren't we, Greg, where you've got this small component issue. Obviously, this was an issue on interchange. Qualcomm, again, can we use a sort of general pass-on rate? RoRo, these cases where you've got small components as a proportion of the total cost base of a car. Can we use a sort of general pass-on rate to answer the question of how a specific overcharge on a small component of the cost base might have been passed on? What are your sort of views on that issue?
Yeah, just before I say that, answer that, there is another important point that, came out of the Supreme Court. I mean, we're talking here about pass-on in terms of prices, but the Supreme Court has now recognized that actually a firm might do many things to mitigate its potential loss. And passing on through prices is one, but it also identified the potential to renegotiate with your suppliers, and you could decrease discretionary expenditure. Now, it kind of separated the discretionary expenditure as something that probably shouldn't be taken into account, because that could have its own potential kind of profit implications if you reduce marketing or advertising or capital expenditure. But the whole supplier point is also potentially relevant. So putting that to one side, I think that my premise is as follows. And again, it's a consideration between theory and practice, and I think it very much depends on how companies go about managing their business. So it's correct to talk about, is a cost high, therefore is it more likely to be passed on? Is it transparent to the consumer? Is it more likely to be passed on? And so on and so forth. But actually, many companies, and certainly not all companies, start from a position where they set a target and then they budget their business to be able to earn a certain rate of return, which is set separately to some of the underlying factors, such as the level of costs. And therefore, if a business goes about setting prices overall to earn a certain rate of return, then in effect, it will manage the business to recover all costs, right? I mean, it's kind of a funny thing that, when I read that, oh, well, that's a small cost, so that would never be passed on. But of course, if there were thousands of these small costs changing in the business, then you would die from 1,000 cuts at the end of the day, right? So depending on the nature of the business, there may be a proposition that, through the qualitative understanding of the business, that pass on is more likely. But putting that to one side, I would say that the problem with some of these small costs is that the econometric techniques, find it difficult to be able to pick up small costs. And I think that what you must then do with the econometrics is to start increasing the costs, right? To looking, including other costs, until you get a statistical reliable result to say, well, we've taken the smallest amount of costs that we can get a statistical result, and it tells us this about pass on. And I think that's potentially what the econometric side of things can tell you.
Yeah, no, that's very helpful. I'm going to sort of perhaps have one last point on pass on. So Jouni, we saw on the RoRo case actually a lot of reliance on the industry expert, and the defendants trying to argue that didn't meet sort of best practice. Any views from your perspective on that sort of particular issue?
I think the pragmatic lesson is that at least the judgment in that case reminded economists that they don't have a monopoly on this pass-on evidence. So I trust that we knew that already, but that underlined it. So I guess you can take quite a pragmatic and quite a holistic approach to the whole issue. So industry expertise can be very persuasive, I think, the short takeaway would be that.
And I wanted to just pick up one point that Vikram made, which is about the the impact that the competitiveness of the market has on pass-on, because I think something that doesn't really come out as clear as it should from the practical guide is actually the bigger driver of pass-on is the extent to which the overcharge is industry-wide and how much you are competing with unaffected rivals. And there was a really interesting case I was heavily involved in the UK, which went to a protracted mediation involving copper tubes, which the vast majority of copper tubes, unsurprisingly, is the cost of copper. And we had this lovely situation where the claimants were arguing for umbrella effects, and so a market-wide cartel, and they were desperately trying to argue that their client was actually a sort of quasi-monopolist and operating in a not very competitive part of the market, because that way they wouldn't be passing on. But when their econometric model showed no umbrella effect, they had to do a volte-face, and they had to argue that no, their market was actually very competitive, because that is the biggest break to pass on will be competing aggressively with unaffected rivals. So watch out for that sort of subtlety. We're just going to finish up. I think I've got 1 or 2 minutes. Just a final reflection from anybody on the panel, actually. What takeaways should we have as experts for how we deploy the evidence in the court? Just looking at some of the interrogations that experts have had in the court. Any reflections on how we deploy our evidence? Greg?
Well, as I said, I think that it's necessary to be balanced. I think that you have to merge both qualitative and quantitative analysis. And, given informational asymmetries, we have to be a little bit more pragmatic. But I think that if we are going to be pragmatic, then I think that it's necessary for us not to try and overextend positions, and trying to take a more conservative approach is probably what is needed in some of these cases, especially, I think, at the CPO stage.
Jouni?
For me, it's being clear about what the economic evidence should be accompanied with. There's an interesting statement in the Forex judgment about this, saying that economic theory does not constitute an arguable claim, and in fact can be difficult to translate into one, and that even refers to possibility of a pre-certification disclosure if it were to be asked, that request would be taken seriously, I think it says. It doesn't say whether it would have been granted in that case, but it's this thing about articulating a very sophisticated theory and it not being persuasive. That is not remedied by making the theory more sophisticated or arguing it in more detail. Something more is required, and I think it's probably the factual background and industry facts.
Thanks very much. Do we have a question? Okay, if we don't have a question, I'll just finish up with one final observation on that last question, which is when we think about the broad axe, we're often required as experts to come up with a range for our quantum estimates. And I was listening with interest to one of my new colleagues who gave a retirement talk and reflected on some of his experiences in the witness box, and recounted a story about how he was being taken to task by an advocate because he was criticizing the opposing expert for having too big a range for his damages estimate. And my colleague was suggesting that actually quite often he didn't actually have any range at all, and the advocate got very excited by this. How can you come up with a damages estimate that you don't have a range on? What is this counsel of perfection? What is this spurious accuracy? And then my colleague just explained that the answer to that was that on many occasions he'd come up with a damages estimate that was precisely 0. Okay, we'll leave it there. Thank you very much. Let's thank the panel.